This presentation is an introduction to Florida legal processes and does not constitute legal advice, and no attorney-client relationship is created. If you have a legal problem or situation related to Florida law, we encourage you to contact a Florida lawyer.
Hi, I'm Jim Walker. Today we're going to offer you a brief overview of small claims court. Have you had your property damaged or destroyed by an individual or a company, and you feel they should be responsible to replace it? Does a company or individual owe you money and not willing to work out a payment arrangement? If so, you could sue them in small claims court. Before we get started on that process, let's break down what is small claims court. If what is owed to you is $8,000 or less, then it can be filed in small claims court. This court hears all cases in which the amount claimed does not exceed $8,000. This excludes costs, interest, and attorney's fees. The St. Lucie County Small Claims Court uses a two-hearing procedure, a pretrial conference with mediation, and a final hearing if the settlement cannot be reached at the pretrial conference. Now, filing the lawsuit. To file your lawsuit, you will need the right paperwork: an original statement of claim, a copy of your exhibit, one copy of all documents for each defendant you're suing, and one copy of all documents for your personal record. If you're using the sheriff's office to serve the defendant with your papers, you will also need a self-addressed stamped envelope for each defendant. This is necessary if you would like a copy of the return of service. To service a defendant who lives outside of Florida, you will also need written instructions to the clerk. These instructions need to include the name and address of the sheriff's office in the state and county where the defendant is to be served. Please also include any special requirements the sheriff has. If you are using a process server, include the name and phone number of the server on a separate sheet of paper. The filing fee is determined by the amount that you are suing for. If you win your case, the judge can also award you court costs. Let's take a look at an example. In this case, a plaintiff sued the defendant for a claim of $2,200. The plaintiff stated, and the plaintiff is the one who's bringing the suit, stated that this amount was 2 months of rent owed to him by the defendant. The plaintiff filed the paperwork to sue, and a pretrial conference was scheduled. At the pretrial conference, the parties reached an agreement for the defendant to pay back the $2,200 to the plaintiff. This case could have had two other outcomes. First, if the defendant did not show up to the pretrial conference, the plaintiff would have been awarded a default judgment plus court costs. Second, if the defendant did show and the parties could not reach an agreement, the trial would have been scheduled for a later time for the judge to determine the outcome. You can download the small claims packets with all the necessary court forms at stlucieclerk.com. Thank you for watching. More legal resources are available at the Rupert J. Smith Law Libraries, or you may visit rjslawlibrary.org.